Andrew Menery when he hands those down. They are on camera. We will hear what he has to say in the next few minutes in sentencing two men, John O'Malley and William Morgan, men who were involved in two separate incidents of disorder over the last week. One of them in Southport back last Tuesday, the day after the deaths of those young girls, of course, and William Morgan accused of his involvement in what happened in Wharton in Liverpool on Saturday night. John O'Malley, first of all, is accused of violent disorder, lives in Southport. The prosecutor, Chris Taylor, said he was in the group of up to 1,000 people who were outside the mosque in Southport in disorder that lasted for hours and saw more than 50 police officers injured and caused significant damage to property. He said, John O'Malley, he said, was active in and at the heart of that violence, which is why he was being prosecuted for violent disorder. He told police he'd been subjected to threats because of his involvement in that disorder. The court was shown a lot of body camera footage and aerial footage of what happened in that disturbance outside the mosque in Southport last week. William Morgan, as I say, accused of possession of an offensive weapon, a wooden bat, when he was arrested after what was happening late on Saturday night in Wharton in Liverpool, after the disturbances here in Liverpool city centre, breaking into convenience stores. A library was ransacked and set on fire, that part of the mob scene that was going on there. And again, body camera footage played to the court of fireworks hitting officers and their riot shields. And they were shown, the court was shown body camera footage of the arrest of William Morgan, where they said he was part of that mob. He had a kosh in his hand. He told officers who were it took 3 officers to control him. He told them he was 70 years old. He had that kosh for his own protection. He's actually 69 years old. He said on that body camera footage, you can hear him saying, "You're trying to kill me." As I say, he was part of that disturbance in Wharton. Again, 100 protesters, the 100 rioters, the police said on that night, setting fire to bins, throwing bricks and glasses, damaging local businesses, damaging that library as well. During the course of what the prosecution were outlining to the judge over the last hour, the judge himself said, talking about what happened in Southport, that there were thousands of people there, hundreds of people there, observing as if it was some kind of Tuesday night entertainment. Those were his words. He said all of those people should be ashamed of themselves for being there and being part of what was witnessed. That was at Southport. We also heard a statement, this was read to the court yesterday as well, on behalf of the Chief Constable of Merseyside Police, Serena Kennedy, on the impact to the community, but also the impact to the force and to the officers, read, as I say, yesterday when a number of other people were sentenced, talking about the fact that 93 officers were injured in this violence. Here are those sentencing remarks now from the judge.
You have both been committed for sentence for separate offences of violent disorder and, in your case, William Nelson Morgan, for an additional offence of possession of an offensive weapon. All of these offences arising out of the deplorable mass public disorder which has taken place in Southport and Liverpool over the past week or so. Every decent member of the community affected by these events will have been appalled and deeply disturbed by what has taken place in their neighbourhoods. You, John O'Malley, committed your offence on the evening of Tuesday the 30th of July in St Luke's Road in Southport. And you, William Nelson Morgan, committed yours 4 days later on the 3rd of August in the County Road area of Wharton in Liverpool. At both these locations there was very serious mob violence, and each of you was at the forefront of that lawless behaviour. Before I turn to your individual offending, let me say something more generally about the background and the factual context within which each of you behaved as you did. On Monday the 29th of July, so a little over a week ago now, a number of families in the town of Southport suffered devastating loss when 3 little girls and numerous other children and adults were brutally killed and seriously injured in a knife attack at a holiday dance class. And while still shocked and bewildered by these terrible events, many residents in the town came together the following evening on Tuesday the 30th of July for a vigil in support of the grieving families. However, at the same time, there were others who saw these events as an opportunity to sow division and hatred, and so published on social media and in printed leaflets false information about the supposed nationality, ethnicity and religion of the attacker. Of course, all of that was complete nonsense, but from that point on, it has been used as a pretext for widespread violence, intimidation and damage, beginning that night in Southport and escalating subsequently across the country, including in this city, Liverpool. On the evening of the vigil in Southport, the police thought that they would be joining a community in mourning. But by the end of the night, those same officers were attempting to defend a part of the town and themselves in what was a pitched battle with a large and utterly lawless mob. It is estimated that there were about 1,000 so-called protesters present that night, though quite what they were protesting about remains a mystery to many. The mob were quite deliberately targeting a mosque, and as officers formed a cordon, they were subjected to repeated foul abuse and threats, and deeply offensive racist language was directed at the mosque and everybody or anyone inside. Over several hours, windows were smashed, walls were demolished, and the bricks were hurled time and again at the police, who were attempting to protect the community. A police vehicle was set on fire, and the mosque was very badly damaged, as were other buildings in the area. Over 50 police officers were injured. And the people doing all of this weren't exercising some right to freedom of expression or lawful protest. Rather, they were exploiting the anguish of others, either to further their own twisted ideology, or more likely, as an excuse simply for vandalism, intimidation and violence. They are criminals, and they do not represent the decent people who were appalled by their behaviour and left subsequently to clean up their mess. Over the following days, there was similar public disorder across the country and at various locations here in Liverpool. On the night of Saturday, the 3rd of August, there was widespread disorder in the Wharton area of the city when many more police officers were injured in clashes with a large crowd intent on causing as much trouble and damage as possible. Now, I have seen a statement written by the Chief Constable of Merseyside setting out in clear terms the consequences of this offending on police resources and effectiveness, and the impact on individual officers who are literally on the front line. In addition to the physical and psychological harm caused to those officers and their families, their enforced absence from duty has increased the burden on those officers who remain, those who are fit to be deployed to protect the communities that they serve. And the extra cost which must be borne by the public is enormous. Southport is a town where families live and work and grow old and take pride in the closeness of such a supportive community. Liverpool is a dynamic city, full of wonderful people who have worked hard to develop a reputation for creativity and enterprise. And your actions, together with hundreds of others, have disgraced and damaged the reputations of that town and this city. It has long been recognised that there is an obligation on sentencing courts to do what they can to ensure the protection of the public, whether in their homes or in their businesses or in the streets, and to protect the places where they live and work. In seeking to achieve this aim, the courts will typically impose severe sentences for offences involving or connected to large-scale and violent public disorder, intended to provide both punishment and deterrence. Quite simply, that those who deliberately participate in such disorder, causing injury, damage and fear to communities, will inevitably be punished with sentences designed to deter others from similar activity. Other offences, such as criminal damage or arson or threatening behaviour or assault or possession of weapons committed in the context of widespread disorder will be regarded as aggravated forms of that offending. Also, it matters not that a particular offender voluntarily present at the scene of a disturbance did not instigate the disorder or play a leading role or themselves throw a missile at the police or cause particular damage. As has often been observed in cases such as this, it is an unavoidable feature of mass disorder that each participant's act, whatever it might have been when considered in isolation, is capable of stirring up and encouraging others to behave in a similar way, and that the harm to the public stems from the combined effect of what is done by everyone who is present. Having set out those general principles, I now turn to deal with the offences to which each of you has pleaded guilty. For the offence of violent disorder and the offence of possessing an offensive weapon, there are sentencing guidelines which I must and will follow. And principally, my task is to determine in each of your cases separately your individual culpability and the harm each of you caused. Dealing firstly with you, John O'Malley. You're 43 years of age now, and you were present from an early stage at the disturbance on St Luke's Road in Southport. There is very clear footage showing the developing disorder, and you were at the front of what was essentially a baying mob. You were part of a surge that broke through police lines, and you were standing next to the police vehicle that was being destroyed. You were present while missiles of every description were raining down on the officers, including bricks, traffic cones, wheelie bins, road signs, tins of paint, and the occasional firework. It was relentless, and you were at the front and participating enthusiastically. I have seen the footage, and there were plenty of opportunities for anyone to leave who did not want to be there. You were arrested 5 days later and made no comment in interview. You have 2 previous convictions, including a recent one for assault by beating. You have, of course, pleaded guilty, and you are entitled to full credit for that plea. I'm told that you now deeply regret what you did on that night. But apart from that, there is very little further mitigation available to you. Turning to the sentencing guidelines, I am satisfied that your offending falls into culpability category B, because you participated willingly in an incident involving widespread and large-scale acts of violence on both people and property, where there had obviously been planning by someone, and it lasted for several hours. In terms of the harm caused, it is category 1, because almost every category 2 factor is present, and they have to do with the significant resulting injury and fear and distress, and the serious disruption and impact on the community. The starting point for a category B1 violent disorder is 3 years imprisonment, with a range up to 4 years. In your case, there are significant aggravating features which have not already been taken into account and which justify a substantial upward adjustment in the starting point. You have a previous conviction for an offence of violence. More significantly, you were part of a crowd using obviously racist and religiously intolerant language that was demonstrating quite deliberately outside a mosque. And you were an active and persistent participant, and this combination of factors takes the sentence, in my judgment, to the top of the relevant bracket. Dealing next with you, William Nelson Morgan, you are 16 now, but your advancing years plainly did not prevent you from playing an active part at the disturbance on County Road. You were a part of a crowd of about 100 people who were running amok, setting fire to bins and damaging local property, including a community hub and library which contained a food bank and provided an important resource for the people living in that area, that library and hub based at Spellow Lane. The crowd threw bricks that night and bottles, and bins were set on fire, and they too were hurled at the defending police officers. As those officers were trying to regain control, you were seen at the front of the mob, holding in your hand a wooden cosh, a small truncheon, which you plainly had with you to use as a weapon. When officers tried to arrest you, you resisted with such force that it took 3 of them to detain you. And later, when asked about the cosh, you said, remarkably, that you had taken it with you that night for your own protection. For the same reasons as your co-accused, I am satisfied that this is Category B1 offending. There is no suggestion that the incidents in Wharton were racially or religiously aggravated, and there may not have been as many people present. But there was looting of commercial premises. There was the wanton attempt to destroy by fire the local library and community hub, and many, many more fireworks were thrown at the police. In your case, there is the serious aggravating factor that you were in possession of a weapon, the cosh, which I am sure you had with you to use to cause injury if the opportunity should arise. It was visible when you were confronting the officers at a time when there was serious public disorder. That factor, together with the other aggravating factors, again justifies a very significant upward adjustment from the starting point, and because of the factor of that weapon, in my judgment, takes your offending beyond the top of that relevant bracket. Because I am taking the weapon offence into account in that way, the sentence for that offence will be ordered to run concurrently rather than consecutively, as might otherwise have been the case. In terms of mitigation, you have no previous convictions at all, and it is very sad indeed to see someone of your age and character in the dock of a Crown Court. That good character is something which I must reflect to some extent in terms of assessing the overall sentence, and the sentence I will pass will reflect it, but the weight to be attached to such mitigation can only be limited given the need in all of these cases for appropriate punishment and deterrence. I impose in both your cases the statutory surcharge in whatever is the appropriate amount, and I make a collection order. The sentences that I am about to impose have been reduced by 1/3 to reflect your pleas of guilty, and you will both serve up to 1/2 of those sentences in custody before you are released on licence. If you fail to abide by the conditions of your licences, you can be returned to serve some or all of the remainder of those sentences. Will you both now stand up? In your case, John O'Malley, for the offence of violent disorder, the sentence is 32 months imprisonment. In your case, William Nelson Morgan, for the offence of violent disorder, the sentence is also 32 months imprisonment. That sentence intended to reflect that offence and the associated offence of possessing an offensive weapon. For the associated offence, there will be a concurrent sentence of 6 months imprisonment, reflecting, as I have, the principle of totality. The total sentence is, therefore, one of 32 months imprisonment in your case. Because of your possession of the weapon, I am also satisfied that it is necessary to make a serious violence reduction order to protect the public from future harm. It will last for a period of 2 years and will not take effect until you are released from custody. Those are the sentences of this court. You may now both go with the officers.
Live sentencing there from Liverpool Crown Court. That was the recorder of Liverpool sentencing John O'Malley and Nelson Morgan. John O'Malley, 43 years old, taking part in disorder in Southport. Footage showed him, the judge said, at the front of a baying mob that broke through police lines. There were missiles being thrown, and that John O'Malley was pictured near the burnt-out police vehicle in Southport. It was a relentless, enthusiastic participant, the judge said, who had 2 previous convictions, one for assault by beating. Well, for violent disorder, the judge just passed a sentence of 32 months. And for Nelson Morgan, who took part in violent protests in Wharton, he said that the 69-year-old was an active part of that, of around 100 people who had racial and religious aggravation and overtones to their protest. He said that bins were set on fire, property was damaged, including a community hub and library that contained a food bank in Wharton. Nelson Morgan, 69, had no previous convictions but was holding a wooden kosh, a small truncheon, and it was said that 3 officers were required to restrain him on that evening. He has just been sentenced also to 32 months. That follows sentences yesterday also at Liverpool Crown Court of 20 months, 30 months and also of 3 years. We'll bring you more details in due course, but we've just been hearing there from Liverpool Crown Court of the sentencing of Nelson Morgan and of John O'Malley, both of them sentenced to 32 months. Well, in the last few minutes, we've also been hearing from the Prime Minister, Sir Keir Starmer. Let's take a listen.
Last night, I think the fact we didn't see the disorder that was feared is because we had police deployed in numbers in the right places, giving reassurance to communities. We were able to demonstrate the criminal justice system working speedily. So yesterday you saw the sentencing of individuals who've been involved in disorder days ago, some of them getting sentences as long as 3 years. That sent a very powerful message. But I also think that the work that's been done jointly to reassure our communities is becoming more effective. Now, it's important that we don't let up here, and that's why later on today I'll have another COBRA meeting with law enforcement, with senior police officers, to make sure that we reflect on last night, but also plan for the coming days.
Things may have died down, but we have seen violent scenes and riots for the best part of a week. Looking across policing and government, would you really say that this has been a success? And what are the lessons that you've learned? What would this government do differently in the future?
The most important lesson is for those involving themselves in disorder, because what we've seen is that those that are being arrested now, numbered in their hundreds, many have been charged, some already in court, and now a number of individuals sentenced to terms of imprisonment. That is a very important message to those involved in disorder. And I say it again, anybody involving themselves in disorder, whatever they claim as their motive, will feel the full force of the law. It's important I repeat that, because we need to make sure that in the coming days we can give the necessary reassurance to our communities, many of whom, I've been talking to some this morning, are very anxious about the situation.
If we have indeed turned a corner and seen an end to the violence, is now the time to engage with the underlying tensions that are in communities over the issue of immigration?
The first priority is safety and security of our communities. And yes, last night was much better than was expected, but we are not going to give up on our efforts here. That's why it's very important that I continue my discussions, coordinating with law enforcement, with police leaders, to make sure we've got the right officers in the right place, to keep pushing on the criminal justice response. I was very keen that we're able to demonstrate that if you're involved in disorder, within days you'll be in the criminal justice system, and some people starting long terms of imprisonment. That needs to continue, and so that is my sole focus. Thank you.
That was the Prime Minister. Let's take you back to Liverpool Crown Court. Greg Milam there. Greg, let's just reflect on those sentences that were passed a few moments ago. Both men pleading guilty, but significant custodial sentences still passed down.
Yes, and the Judge, Andrew Menery, saying that this was very serious mob violence, and each was at the forefront of that violence, talking about the background of what had happened last Monday and the deaths of those children in Southport, but saying that some people saw that as an opportunity to sow division and hatred, talking about the nonsense on social media that led to this widespread violence and damage, exploiting the anguish of others, and very much pointing to those in the dock and saying that the fact it was part of mob violence has increased the sentences, and those sentences designed to deter others from taking part in that kind of violence. John O'Malley, involved in those scenes in Southport last Tuesday, present from an early stage at the forefront of a baying mob, he said. He and William Nelson sentenced to 32 months each.
Greg Milam in Liverpool for us. Thank you so much. And we'll have plenty more on the situation across the last few days, the sentences, the arrests and reaction from both the police and the government throughout the course of the day here on Sky News. Do stay with us because the Chief of the Metropolitan Police says fears of violent disorder were quashed. That was thanks to a show of unity from officers and communities. We'll have more reaction in the coming hours.